Every state faces a core paradox when writing its constitution. The document must be rigid enough to remain the supreme law of the land, but it has to be flexible enough to govern a living, breathing society that evolves over time. When that balance fails, the results are cataclysmic. If the system is too rigid, it will shatter under the immense pressure of societal change. If it's too flexible, it ceases to function as the supreme law and devolves into mere suggestion. To survive, legal systems rely on two main mechanisms for adaptation. The first is formal amendment. These are explicit changes made to the written text through official procedures, a method heavily favored in civil law nations. The second mechanism is the informal amendment. In common law countries, courts can alter the practical operation of the Constitution without ever touching the written text itself, usually through binding judicial interpretation. Take India as an example. In the 1978 Maneka Gandhi case, the Supreme Court informally amended the Constitution by reading Article 21, the right to life, alongside Article 19. This established that any procedure depriving someone of personal liberty must be just, fair, and reasonable, a significant expansion of rights achieved without a single legislative vote. Updating a nation's legal framework without destroying its foundational integrity is the greatest engineering challenge in constitutional law. When a nation opts for a formal amendment, the process universally involves three stages: initiation, adoption or approval, and ratification. This dashboard maps the formal amendment architecture across different nations. Looking closely at the United States, under Article 5, the threshold is exceptionally high. An amendment requires a 2/3 vote in both houses of Congress, funneling down to a ratification requirement of 3/4 of all state legislatures. Notice the executive branch on this map. The U.S. president has absolutely no role in this process. As confirmed in the 1798 case, Hollingsworth v. Virginia, the president cannot veto an amendment. The rationale rests on the separation of powers. Constituent power flows directly from the will of the people, keeping the indirectly elected executive entirely locked out. That high barrier means most attempts to change the system die right here on the floor of Congress. Australia takes a completely different approach under Section 128 of its constitution. Instead of relying solely on state legislatures for ratification, Australia mandates a public referendum. Shifting our map to Australia, we see this mandatory public vote introduces an intense constraint called the double majority. To pass an amendment, a proposal needs a national majority of all voters, plus a majority in at least 4 out of the 6 states. Voting in these referendums is compulsory, forcing the entire electorate to weigh in on structural changes. Out of 44 proposals in over a century, only 8 have survived this threshold. Imposing these massive procedural hurdles acts as a deliberate feature of statecraft, not a bug. They ensure that formal systemic change remains rare, protecting the document from the whims of temporary majorities. India's legislative arena sought a compromise between the near impossibility of the American system and the flexibility of an ordinary parliament. Dr. B.R. Ambedkar designed what he called a middle path for India, structuring Article 368 to handle different types of legal updates with varying degrees of friction. This pyramid illustrates India's 3-tiered system. The bottom tier allows minor changes, like altering state boundaries, with a simple majority. The second tier requires a special majority, more than half of the total membership, plus 2/3 of members present and voting. The highest tier, reserved for federal changes, demands that special majority plus ratification by half of the state legislatures. Crucially, the system bans joint sittings of Parliament for amendments, forcing survival independently. And unlike the United States, the 24th Amendment dictates that the Indian president must give assent to a constitutional amendment bill once it passes. India's hybrid model proves that procedural design can effectively categorize the severity of structural changes, tailoring the friction to the magnitude of the update. But procedure only answers how an amendment is passed. It avoids a deeper structural question. Are there limits on what a legislature can amend, even if they follow all the rules? The theoretical foundation for placing limits on the substance of an amendment comes from the French thinker Emmanuel Sieyès. This schematic maps Sieyès' philosophy. At the origin is constituent power, the unlimited, primal authority of the people to create a state from scratch. This power drafts the original constitution. The constitution then establishes constituent power. This is the strictly limited authority granted to bodies like a parliament. They only possess the power explicitly delegated to them by the foundational document, which leads to the core axiom of substantive limits. An amending parliament cannot legally use its limited constituent power to destroy the original document that gave it life. This distinction acts as a safeguard. It restricts a modern government from legally erasing the original will of the people, no matter how large a majority they hold in a legislature. Following the Second World War, Germany engineered Sieyès' philosophy directly into its legislative text. To prevent the legal dismantling of the state from within, the framers wrote Article 79, Clause 3, known globally as the Eternity Clause. This clause places specific foundational features permanently beyond the reach of amendment. The federal structure, human dignity, and the democratic rule of law cannot be altered by any parliamentary majority. They even included a failsafe in Article 20, granting German citizens an absolute right to resist anyone attempting to abolish this constitutional order. Returning to India, we find a vulnerability. The Indian Constitution contains no explicit eternity clause to stop a rogue legislature from legally dismantling the democratic order. This timeline tracks the power struggle that followed. In early cases, Shankari Prasad, Parliament dominated, claiming unlimited power to amend fundamental rights. But by 1967, in the Golok Nath case, the Supreme Court overcorrected, ruling that Parliament had no power to amend fundamental rights at all. Parliament retaliated. They passed the 24th and 25th Amendments, inserting clauses specifically designed to shield their laws from judicial review and assert absolute constituent power over the document. This set the stage for a legal showdown that would force a final decision on whether Parliament's amending power had any boundaries at all. In 1973, a 13-judge bench convened for the monumental Kesavananda Bharti case. By a razor-thin 7-6 majority, the court synthesized the basic structure doctrine. They ruled that while Parliament can amend any part of the Constitution, it cannot destroy, damage, or abrogate its basic structure. When a Constitution lacks a textual eternity clause, judicial implication of substantive limits is the only defense against a legally sanctioned systemic collapse. The doctrine's durability was measured for the first time during the era of the emergency. Parliament passed the 42nd Amendment. Clauses 4 and 5 were inserted directly into Article 368 to declare that there was no limitation whatever on Parliament's amending power, effectively trying to legally erase the court's oversight. The Supreme Court issued a decisive response in the 1980 Minerva Mills case, striking down those exact clauses. The court reinforced Sieyès' logic, stating plainly, the donee of a limited power cannot, by the exercise of that power, convert the limited power into an unlimited one. A limited amending power is itself a basic feature of the Constitution. In the decades since, the doctrine has consolidated, protecting federalism in the Bombay case and judicial independence by striking down the 99th Amendment in the NJAC case. A state's legal foundation must endure constant pressure from the society it governs. Without structural safeguards, it either snaps or bends until it loses meaning. Unlike the United States and Australia, where the judiciary generally checks only procedural compliance, India actively reviews the substantive validity of constitutional amendments. The amendment process functions as the barrier between democratic evolution and total legal destruction. Take a close look at your nation's system to see exactly where that wall is built.